Good morning. Welcome to our session on claims broking today, which is a follow-up to the really interesting session that our colleague James Thompson hosted with our external guest speaker, Flora McCabe from Lockton. If you haven't tuned into that previously, it's available as a recording via our website. So your speakers today, I'm Ben Hardiman, a partner in our insurance dispute service line. And one of the areas I specialise in is claims against insurance brokers. I'm joined today by Lucy Wood, who is an associate. She's recently been on secondment to Manchester Underwriting Management, where a lot of her time was spent dealing with claims against brokers. So she's got some recent experience of dealing with claims. Quickly on the housekeeping, the usual things, the session's being recorded and it'll be available to view later. And of course, if you've got any questions, please feel free to pop them in the Q&A box and we'll try to address as many as we can. If we can't get to all of them, if you've provided your email address, we will follow up by email. So, agenda. We're going to talk about the scope of a broker's duty when it comes to handling your client's claims. So that's my part. Lucy will then take you through notification, which is of course probably the major aspect to consider when your client experiences a problem. And then I'll conclude with some practical hints and tips to help you through the claims process. So with that, let's kick off with scope of duty. As the invite said, and you'll all have seen, as a broker, you've won the client, you've placed their risk, and you then diary it forward for renewal purposes in 11 months, which is fine until a problem arises mid-year. Now, I think in general terms, it's going to be accepted that once you become aware of a problem, unless it's been expressly agreed otherwise, a broker is going to have a continuing obligation to deal with any claims which arise during the policy year. That's going to include advising the client about the notification requirements within a policy and ensuring that the claim or circumstance is notified to the insurer within the time limits contained within a policy and in accordance with the terms of that policy. Now, what about if there's no express agreement? That can become an issue, which is why I wanted to mention the first case on the screen, which is known as Invulner Management and April Grange. Now, actually, it's a decision which is mostly focused on the original placement of the risk. So there were presentation issues which gave the underlying insurer a basis to decline. But this was a claim in relation to a high-value super yacht, which was damaged by fire. And beyond this, the presentation issues, the broker also faced allegations in relation to failures after the claim was made. And in particular, the broker was said to have failed to advise the policyholder about the intricacies of making a claim, and particularly the need to file a sworn proof of loss within 90 days. The policyholder had failed to do that, and the insurer had relied on that failure. The policyholder then attempted to argue that its failure to complete that proof of loss was because the broker had failed to advise it to do so. Now, I think this situation is fairly fact specific. The situation before the court was pretty unusual. This was a Greek producing broker placing into London or Lloyd's in London via a placing broker in London. And the claimant yacht owner didn't cite any legal principle or authority to persuade the judge why, as a matter of customer practice, a broker had to give this advice, even when it hadn't been advised to do so. It also adduced no expert evidence to support that proposition. It was also apparent that the policyholder had other advisors providing advice about the claims process. So the judge held, and you'll see the quote on the screen, that the claimant had fallen a long way short of establishing that a reasonably competent broker should have given advice about the requirements relating to a claim, even when not asked to do so. So on the face of it, this is a really helpful case for brokers. But as I say, I think it's fairly fact specific, and I'm not convinced it tells the full story. And I'll sort of outline that full story by the two cases that I've included on the next slide. So the first of those is really a question of who are you advising and what do you have to do? And the question of acting as a postbox comes up. Now, this is something that Lucy will touch on in a moment, but this, I think it helps visualize what a court will expect of you. In short, you can't, as a broker, act as a postbox. You can't simply pass on details to insurers without any thought. The court is going to expect more of you. So just to the facts, so from left to right on the screen, you've got SBJ, who are the professional indemnity broker for the policyholder, Alexander Forbes. Forbes held two policies, one their general group policy and one a run-off policy for its IFA business. Forbes sent details of a claim to SBJ for onward transmission to their E&O insurer, and SBJ only notified the group policy. A couple of months later, 12 days after expiry of the policy, so after renewal, they realised that the IFA aspect was excluded from the group policy. So when they belatedly attempted to notify to the IFA policy, the insurer refused to accept that notification. Now, this case is really interesting on two counts from the perspective of duty. Firstly, this is a situation where SBJ are advising a really quite sophisticated client. They've got a professional indemnity insurance broker as their policyholder. That broker, Alexander Forbes, had given their own views about who to notify. And despite that, SBJ was held to have a duty to advise. Secondly, and going back to the postbox point, the court held it wasn't sufficient for SBJ to simply look at the heading on a letter and pass it on to the insurers. They had a positive duty to consider the information received from the client and to provide advice accordingly to ensure notification was effected properly. SBJ knew there were two separate policies, and they had an obligation, in the judge's words, to get a grip on the proposed notification to ensure it was relayed to the right insurer in the right form. Now, I think this situation facing SBJ was pretty complicated. There's no doubt about that. There's two PI policies, there's different entities, and there are issues in the claim that aren't necessarily that clear. But I've dealt with similar claims in the past where brokers haven't properly understood the claim being made. They've just simply pinged it off to the insurer they thought would respond. And this happens in particular in construction. So, for example, there may well be a PI policy, a PL, products, some form of all risks insurance. Now, there may well be a composite policy which covers some or all of these types of insurance, but not necessarily. And each of those policy covers may be triggered. Selecting the wrong one potentially leaves the client in a difficult position. And if that occurs, it's going to be you as the broker and not the client who is the one who ought to have determined who and what should have been notified. Now, before I hand over to Lucy to discuss notifications and to sort of drill into the intricacies of that, there is one further case worth mentioning briefly, just because it shows the expectations of the courts in these sorts of situations. And that's at the bottom of the screen, Ocean Finance and Oval. That's a case involving a producing and a placing broker. And the court held that a placing broker had a duty to review information provided to it during the renewal process. So not in the context of a, please see this information about a new claim, and to consider if a notification of circumstances, and particularly a block notification, should be made to the expiring policy before renewal. Now, this was in the context of a PPI mis-selling in circumstances where the policyholder had 37 financial ombudsman service decisions against it. And the judge expressed the view that had the broker reviewed those 37 decisions, that would have revealed that there was a fundamental argument against the policyholder with a fundamental common cause. Knowing that would have led to the broker making a recommendation that a block notification should be made. Now, this strikes me as a really quite harsh decision. How many brokers out there are reading that level of information to fully assess and understand the claims their clients are facing? Not only that, but this information was provided in the context of renewal discussions. It wasn't in relation to please notify these claims. But I think what it shows, and contrary to the April Grange decision I mentioned earlier, it just shows how high the court's expectations will be of you. Now, on that note, Lucy's going to take you through notification and what might be required in terms of a claim or a circumstances. So, Lucy.
Thank you, Ben. Now let's start by looking at notification requirements within policies. Every policy will contain notification requirements. For example, the insured may be required to notify in writing and provide the potential claimant's names and the details of the claim, including relevant dates. As a broker, you should try to ensure that you have all the information required under the policy before notifying. The policy will also require the insured or its broker to notify within a certain time frame. This is usually as soon as practicable or as soon as reasonably possible. It is important to comply with these timeframes, but it is also important to gather the information required to make a valid notification. Further, it is important to check the policy, as this will inform you, as the broker, whether the notification requirements are a condition precedent. As most of you will know, a condition precedent is a contractual term which, if breached, may entitle an insurer to reject the claim or may mean that cover never attaches. Therefore, in the event the requirements are a condition precedent, if they are breached, it will prevent the insured from making a claim. Next slide, please. As a broker, you should consider whether the event you are seeking to notify on behalf of the insured is a claim or a circumstance. You must remember the definitions of claims and circumstances will vary from policy to policy, and it's always important to check the definitions. Sometimes, brokers may only consider letters of claim and the issuing of proceedings as a claim under a policy, but it is likely that the definition of a claim will be far wider than this. Our example standard policy definition of a claim includes a demand for damages and even an intimation or a threat of an intention to seek damages, which is quite a low threshold. The policy definition of a circumstance is just as important to insurance brokers, because if a notification isn't a circumstance, then it should not be noted against a policy. Equally, if a circumstance does arise, it must be notified. A policy definition of a circumstance can be really quite broad and cover small complaints which could be made by one sentence in an email or verbally during a telephone call with a potential claimant. It's important that brokers are aware of the policy definition of circumstance to avoid any issues with late notification. As our example on the slide shows, the definition of circumstance can refer to matters that may give rise to a claim or are likely to give rise to a claim against an insured. Although phrases such as likely and may are not the most helpful, as a general rule of thumb, likely is more than a 50% chance, and may is a lower threshold with more than just an outside chance that a claim may arise. For example, if an insured accountant rushed to submit a tax return without checking all the information was correct, and a month later he receives an email from the client saying his tax liability is much higher than expected and he is holding the accountant responsible, it would be reasonable to say this scenario is likely to give rise to a claim. Whereas, if the same accountant submitted a tax return and before submitting checked the information was correct with the client, and a month later receives an email saying his tax liability is higher than expected, and he asked the accountant to double check the figures, this scenario may give rise to a claim. Next slide, please. How much information is required and how specific does the information need to be in order to make a valid notification? In an ideal scenario, the notification of a circumstance would enable an insurer to not only identify the potential claimants and understand the basic details of the matter, but it would also inform insurers of the exact issues, scale, consequences, and potential causes of action of the matter. However, this is rarely possible and it's accepted by the courts. The Court of Appeal in Europol's and Royal Sun Alliance considered the topic of notifications and attachment of claims in professional indemnity insurance, and in giving judgment, Dame Elizabeth Gloucester helpfully summarised the key principles of whether there has been a notification of a circumstance under a claims-made liability insurance policy, and it is clear that the threshold is low. The principles can be summarised as follows. The test that notified circumstances may give rise to a claim set a deliberately undemanding test. It required only a possibility of claims in the future and not a certainty. Further, the insured may give a can of worms or hornet's nest notification. This is a notification of a problem, the exact scale and consequences of which are not known. Finally, the insurer does not need to know or appreciate the cause or causes of all the problems that have arisen or the consequences which may flow from them. Next slide, please. As we have discussed, policies will require that both claims and circumstances be notified. It is also clear that circumstances may give rise to claims. So what happens when this occurs? If a claim does relate to an earlier circumstance, if we are dealing with a claims made policy, which most professional negligence policies are, then the claim will attach to the policy under which the circumstance was notified. To determine whether the claim and circumstance are connected, you must assess the facts, as there must be some causal as opposed to merely coincidental link between the notified circumstances and the later claim. This is one reason why there is a continuing obligation on brokers to remain updated in relation to circumstances. When you find yourself in this situation, you, as a broker, may need to review the facts of the claim in order to determine whether it relates to an earlier circumstance, which when notified may have contained very limited information, as this will establish which policy the claim attaches to. Further, this will also determine the relevant policy terms and the applicable excess. And you, as a broker, may need to explain to an insured why their claim is attaching to a certain policy. Now back to Ben with some practical hints and tips.
Thanks, Lucy. So I'm just going to round up to give you just some thoughts on how you might deal with a few other issues. So firstly, what we've discussed so far has been focused on claims made policy. So for example, PI. There are still notification obligations in relation to claims occurring policies. So for example, EL or PL insurance. The requirement to notify isn't particularly different, but it's generally going to be more straightforward for you and the policyholder to work out if the insurable event, so for example, an accident at work, has occurred. So really, it's more akin to the claims situation as opposed to the circumstances situation that Lucy has discussed. What about excess layers? I think this is an important area and potentially one that gets missed. How far up the tower of insurance might you go? I've defended insurance brokers who were informed of what looked like a relatively minor or innocuous claim or circumstance at the outset, and which they only noted to the primary layer insurer. But when the underlying claim then later explodes and excess layers potentially become exposed, excess layers have relied on those failures to notify at the outset to reserve rights and decline cover. Now, in some ways, it's no different. As with the primary layer, it's important to consider the policy wording. Many excess layer policies will follow the primary layer. Some will say something like notify if the claim may or is likely to exceed 50% of the primary layer. However, I'm aware of one major broker who notifies every matter to every layer, irrespective of size and irrespective of the policy wording. Now, I'll leave you to decide if that's appropriate or not, but it's certainly the most defensible strategy available for a broker. And then finally, I've put on the screen, be careful what you say, because this is something that we regularly see in situations where a claim is directed at a broker. Because we've seen numerous instances of brokers trying to do the right thing and laudably trying to do the right thing by their clients by responding at the point of the insurer reserving rights, only to give their client ammunition which helps the client pursue the broker in a subsequent claim for negligence. Now, an example of this can be seen in the Alexander Forbes case I mentioned earlier. When SBJ attempted to notify to the second policy, the wording that they used to the second insurer was on the screen. This matter was originally notified under the group policy, but at renewal, it was noticed that the subsid was in fact excluded under that policy as they hold their own PI cover. Now, perhaps unsurprisingly, when the IFA policy then declined cover, Alexander Forbes were able to point to this statement as evidence that SBJ had misunderstood the position at the point they'd been informed of the problem. Now, brokers will often be in the firing line if an insurer is able to decline cover for a claim. So while you are right to try to do what you can to promptly respond to any indication from an insurer that rights are reserved or the cover is to be declined, in order to try to get your client back on risk, just take a step back before you say anything. Put the email in your drafts and reread it later. Think about what you are proposing to say and how that might be construed later down the line by the claimant itself, the policyholder, or the court, if that insurer does ultimately not provide cover. That wording potentially trips you up in future. So I hope you've enjoyed the session. I hope you found it helpful. We do have a little bit of time remaining for some questions. And so Harriet Strevens has been picking up those in the Q&A box and will grill us now if there are any.
I'm not so sure about grilling, Ben, but I'll certainly have a good go. I think some of these questions possibly touch upon some of what you've already said, but they're certainly worth repeating, and perhaps you could embellish the answers. One of the first questions that we've got is, why not notify everything as a matter of precaution? Surely that can't hurt anybody.
I'll take this one, Harriet. Well, no insured wants their policy laden with claims notifications which may not come to anything but can increase premiums as an illustration of a bad risk. Equally, no insurer wants to have to consider reserving for losses which might never materialise. So you do really need to understand what the facts of the notification might be and the policy conditions of notification.
So a bit like Russian roulette on one hand.
Yes.
Yeah, and Harriet, actually, interestingly, it goes that excess layer point I mentioned earlier.
Yeah.
Some brokers take the view, notify everything, and that removes the risk from them.
Yeah, interesting observation there. What about this question, Ben? You mentioned that if you tell insurers everything, which the questioner has always thought you should do, it might come back and bite you. Well, why is this?
Well, I suppose that there's always a risk that the advice that you are giving has ramifications, and you've got to ensure that the client is doing the right thing by way of the policy. That's the most important thing. It potentially comes back to bite you in circumstances I mentioned earlier. You know, the insurer able to rely on something that later puts the broker in a difficult position.
It is a complete minefield, isn't it? And I'm sure a lot of the audience will be nodding heads at the answers that you've given.
I think that's
we are pretty much out of time, and given our desire to want to comply with the advertisement that we don't waffle on, I'll pass the baton back to you, Ben, to close up.
Thank you very much. Well, the slides will be sent to you in due course. If there are any other questions sat in our list, if your email address is provided, we'll try and pick them up by email afterwards. Please do fill in the questionnaire that you'll receive after the question. We find it really, really beneficial knowing that we are hitting the right subjects, that there are subjects out there that you want us to talk about. And on that note, this was the second in our little mini-series aimed at claims. We are working on content for the next few sessions, but if you put something in the feedback, we'll be delighted to use future box webinars to cover any topics that you're interested to hear about. And then just finally, before I pass on, don't forget this is a bumper week of webinars for Mills and Reeve in our insurance dispute service line. We've got Breaking Ground tomorrow, that's aimed at construction professionals. We've then got a cover talk on Thursday, which is about solicitors going rogue, which I think I'm going to listen into. That sounds pretty exciting. If you are interested, you can sign up to those on our website. So thank you very much for listening to us today. Goodbye.